Hello and welcome. Thank you for joining us. My name is Paul Maguire, Principal Lawyer of Maguire Legal. I'm presenting this webinar today with my colleague and fellow lawyer, Etta Gull. Etta, for those who don't know her, joined Maguire Legal full-time in July 2025, primarily advising our clients on all aspects of employment and workplace relations obligations, as well as coordinating our representation of employers in unfair dismissals and adverse action claims. Most recently, Etta has been turning her knowledge and skills to labour hire registrations and representing clients in that particular area. So for those of you who don't know Etta and want to get to know her better, then we welcome her today because she'll be doing most of the presentation. Our topic today is Sleepovers under the Social, Community, Home Care and Disability Services Industry Award 2010. Since the creation of this omnibus SCHADS Award in 2010, employers have been operating with an award framework that never really clearly answered a deceptively simple question. And that question is, what is the proper characterisation of the sleepover? When an employee works before a sleepover and after a sleepover, is that one shift or is it two or is it a break? The characterisation of sleepovers has been the subject of Fair Work Ombudsman attention, federal court decision last year, and in later 2025, the Fair Work Commission decision to vary the sleepover provisions of the award. So today's session is about primarily what the Commission has decided in varying the award, what it's proposing to change, and how employers and leaders within those businesses, organisations should think about the risk of decision-making during this transition period to the new provisions. Finally, I would indicate that we've allowed time in the final section of this webinar for a Q&A. So please use, you'll see on the top of the Teams screen that there's a Q&A button to log your questions. So if you can put them in there, we will deal with them in the later section of this webinar. But we'll kick off now. Etta will take you through the legal backdrop and some further background to the Fair Work decision. So over to you, Etta.
Thank you so much, Paul, and thank you everyone for joining us today. To appreciate why this decision matters, we need to briefly step back. The SCHADS Award has contained sleepover provisions since 2010, and those provisions were designed to support overnight care while recognising that employees were not continuously performing active duties. Over time, however, tension emerged between different parts of the award, and those were provisions dealing with sleepovers, those that dealt with rest breaks, and provisions dealing with shift work and penalties. The award never clearly explained how those provisions interact when work is performed on both sides of the sleepover. So employers filled the gap with operational practice and regulators filled the gap with enforcement positions, and eventually the disagreement ended up last year in 2025 in court before the Commission. This issue escalated beyond normal compliance conversations and into litigation and award reform. The immediate catalyst was the Fair Work Ombudsman enforcement position. The Ombudsman issued a compliance notice asserting that an employer had underpaid an employee because, in the Ombudsman's view, work before a sleepover, the sleepover itself, and work after the sleepover, together formed one continuous shift, triggering night shift penalties and potentially overtime. Under that approach, work performed before a sleepover, the sleepover itself, and work performed after the sleepover were treated as forming one continuous shift. That interpretation had very real financial consequences, and it meant that shift penalties, particularly night shift penalties, were set to apply across the entire shift, even where the employee was not actively working for significant portions of the night. And importantly, this was not simply guidance or commentary, it was enforcement action backed by a compliance notice, which carries significant legal and financial consequences if not complied with. The employer challenged that compliance notice, which led to the SCHADS joint litigation in the federal court. Once the issue reached the Fair Work Commission, it became clear that there was no single uncontested interpretation of the SCHADS Award. Employer groups, including AI Group and Parkerville, advanced that position that a sleepover should be treated as a break. And under that model, work before and after a sleepover would be treated as two separate shifts, which would generally avoid the application of extended shift penalties and overtime. Unions advanced the opposite position. They argued that a sleepover does not constitute a break at all, and that work before and after a sleepover should be treated as part of one continuous shift with penalties flowing accordingly. These positions were fundamentally incompatible, and they also reflected the reality that different parts of the award appeared to pull in different directions. What is particularly important for leaders to understand is that despite their opposing conclusions, both sides did agree on one critical point, that the SCHADS Award was ambiguous. That shared acknowledgement is what enabled the Commission to step in under Section 160 of the Fair Work Act, and the Commission's role at that point was not to choose a winner or who was right or wrong, but to determine whether the award failed to provide a clear and workable safety net, and if so, how that should be corrected. And this is a key governance moment. When the Commission varies an award to remove ambiguity, it's not punishing past behaviour. It's attempting to make clear and clarify future compliance and reduce systemic risk across an industry. The applications before the Commission framed the issue in a way that went beyond individual disputes. They raised a broader question. How should overnight care work be structured in a way that is legally coherent, operationally viable, and fair? The answer the Commission ultimately delivered, and what we'll refer to, is the hybrid solution, which flows directly from this contested background. This reform did not raise from a single bad actor or isolated compliance failure. It arose because the award itself could not reliably support the complexity of modern care arrangements. And that context is essential when thinking about risk, implementation, and how regulators are likely to view employer behaviour going forward. So in July 2025, the Federal Court delivered its decision in SCHADS Joint and Fair Work Ombudsman. And this case was not about whether sleepovers are fair or reasonable. It was about whether the Ombudsman interpretation of the SCHADS Award was legally correct. The case arose from a compliance notice issued by the Ombudsman mentioned a couple of slides earlier. And the Federal Court ultimately rejected the Ombudsman's position and set aside the compliance notice. It accepted that sleepovers are a distinct arrangement under the award, paid via an allowance, and not automatically treated as time worked. In doing so, the court confirmed that the award did not clearly support the Ombudsman interpretation. And many employers, understandably, took comfort from that outcome. However, the court did not say the award was clear in the opposite direction either. What it revealed was a deeper problem in that the award itself was capable of more than one interpretation. So once the federal court has effectively said this award is unclear, the Commission is almost compelled to address that uncertainty to stabilise compliance expectations across the sector, and that's exactly what happened next. In December 2025, a full bench of the Commission handed down a decision in response to applications from employer groups and unions. The most important finding was not about who was right or wrong historically. The Commission found that the SCHADS Award is ambiguous and uncertain in how it treats work performed immediately before and after a sleepover. This led to varied interpretations by employers, unions, and the regulators over time. The Commission acknowledged that the Federal Court had interpreted sleepovers as separate and distinct periods of time that do not, of themselves, form part of a shift. However, the court also recognised that sleepovers require the employee to remain on site and to maintain continuous responsibility. Building on that background, the Commission found that a sleepover should not be treated as a break in the ordinary sense. The full bench made clear that a break in the context of clause 25.4 of the SCHADS Award is a period during which the employee is released from work and responsibility. The Commission explained that during a sleepover, the employee must remain on site, remains responsible for clients, and may be required to perform work at any time. Even though the employee may be permitted to sleep, is able to do so, they are not genuinely relieved of responsibility. Hence why a sleepover could not be characterised as a break, and that a true break requires genuine relief from responsibility and duty. This finding matters because many rostering models had implicitly treated the sleepover as a rest period that effectively separated two shifts, and the Commission rejected that conceptual approach. The Fair Work Act allows the Commission to vary an award specifically to remove ambiguity. In other words, the Commission was not punishing employers, it was acknowledging that the award itself failed to provide a clear rule. And from a governance perspective, this is significant because it confirms that many employers have been operating in good faith within an unclear regulatory framework. And the decision necessitated immediate changes in rostering practices to ensure compliance and minimise potential liabilities. So the question most asked at this point is, does this expose us to years of back pay liability? And the Commission answer was no. It expressly refused to apply the variation retrospectively, finding that there were no exceptional circumstances justifying reopening arrangements back to 2010. The Commission's decision avoids automatic back pay obligations, alleviating major financial concerns for employers. That decision significantly limits systemic risk across the sector. However, it's important to be precise. This does not eliminate all historic risk. It means that the Commission has not changed the rules backwards. And historical risks depend on specific circumstances, such as enforcement history and accuracy of payroll records maintained by employers. Individual exposure will still depend on factual compliance and with the award as it stood, payroll accuracy, and enforcement history. So employers must remain vigilant and proactive in their compliance strategies to mitigate potential risks moving forward. So where are we now? We are in a defined transition phase. Submissions on the proposed award variation close on 30 January 2026. And after that, the Commission will issue a final determination with commencement tied to the first full pay period after the operative date. So until then, employers are operating in a space where the federal court has interpreted the award in one way, the Commission acknowledged ambiguity, and a new framework is clearly coming, but has not yet been confirmed. And this is a period that requires careful, defensible decision making. So there are some proposed changes, and understanding how sleepovers will be managed is key in creating solutions that balance both employer needs with employee rights. The Fair Work Commission has proposed variations to the award, pending further consultation with interested parties, which will be explained in the next few slides. One of the most significant and practical elements of the proposed variation is the introduction of a 12-hour shift option by agreement. Under the proposed variation, employers will be able to offer shifts up to 12 hours by agreement, allowing for more flexibility in scheduling. Historically, the SCHADS Award permitted ordinary shifts of up to 8 hours or up to 10 hours by agreement, and that structure never sat comfortably with sleepover models, where work is often required both late in the evening and early the following morning. Rather than forcing those arrangements into technical non-compliance, the Commission has chosen to explicitly accommodate them. Under the draft variation, where a shift includes work immediately before and immediately after a sleepover, ordinary hours may be worked in a shift of up to 12 hours, provided that no more than 8 hours are worked on either side of the sleepover, and provided there is agreement. This is not a blanket permission for longer shifts. It's a targeted solution for a very specific operational problem. The key takeaway is that this change legitimizes certain rostering practices, but only where they are properly structured, capped, and supported by agreement. Informal arrangements, or this is just how we've always done it, will not be enough. All agreements regarding shift lengths must be documented and clearly communicated to maintain legal compliance and avoid disputes. Rest breaks and shift rules are one of the most conceptually important part of this Commission's decision because it forces organisations to rethink how sleepovers are classified at a structural level. Historically, many employers treated a sleepover as if it operated like a long overnight break, effectively resetting the clock between two periods of work. That approach was understandable, but the award never expressly said otherwise. The Commission has now drawn a clear line in that a sleepover does not constitute a rest break between shifts. Instead, work performed immediately before and immediately after a sleepover is treated as part of the same shift for rostering purposes. The reasoning behind this is important for leaders to understand. The Commission was not making a moral judgment about whether employees deserve rest. It was making a legal and industrial assessment about what a rest break actually means. In industrial terms, a rest break requires genuine disengagement from work, the ability to leave the workplace, disengage from responsibility, and manage one's time freely. And during a sleepover, none of these conditions are met. The employee must remain on site, remains responsible for clients, and may be required to perform work at any time. Even where sleep is possible, it's conditional and interruptible. The Commission took the view that this is fundamentally different from rest. For organisations, this has two significant implications. First, it changes how shifts must be conceptualised. You can no longer rely on the idea that a sleepover breaks a shift in a way a meal break or overnight break would. That conceptual reset is no longer available under the proposed award structure. Second, it is a direct flow-on effect for systems and compliance. Rostering tools, payroll engines, and internal policies that assume two separate shifts on either side of a sleepover will need to be revisited. From a governance perspective, this is less about changing how services operate day to day and more about ensuring that internal systems reflect the legal reality the Commission has articulated. This change should be viewed as a structural clarification rather than a punitive rule. It's about aligning the award with the reality of overnight care work and not restricting service delivery. Having said that a sleepover does not break a shift, the Commission was acutely aware of the potential cost consequences of that finding. If the Commission had stopped there, employers could have faced a situation where an entire shift was treated as a night shift simply because it spanned midnight, even when the employee was asleep for most of that time. The Commission expressly avoided that outcome. Under the draft variation, although the work before and after a sleepover is treated as part of the same shift for structural purposes, the application of shift penalties is assessed separately for each portion of active work. This is a critical distinction, and it reflects the sophisticated understanding of how work is actually performed in care settings. In practical terms, it means that work performed in the afternoon or evening before a sleepover attracts the relevant afternoon or evening loading. The sleepover itself attracts a sleepover allowance, not shift penalties, and work performed in the morning after a sleepover is assessed independently for whether any night or public holiday loadings apply. This avoids the all or nothing problem that concerned many employers, where a single minute of overlap could convert an entire shift into a penalty-laden night shift. And this is one of the most commercially stabilising aspects of the proposed variation because it aligns remuneration with actual work patterns rather than technicalities. However, this is also where implementation risk sits. Payroll systems must be capable of distinguishing between the pre-sleepover and post-sleepover portions of work. If systems are configured to treat the entire shift homogenously, penalties may be over or under applied. The Commission has provided a fair and balanced framework, but it assumes a level of payroll and rostering sophistication. And organisations that do not review and test their systems risk unintended non-compliance, even where their intentions are sound. This is why we consistently say that sleepover compliance is not just a legal issue, but it's a systems and governance issue too. Overtime, particularly for part-time and casual employees, is often the most underestimated source of exposure in SCHADS compliance. Many underpayment issues do not arise because employers intentionally underpay staff, but because the interaction between rostering practices and payroll rules is misunderstood or misconfigured. Sleepovers magnify that risk. Under the proposed variation, the Commission has made two important technical adjustments. First, overtime triggers are clarified to apply per day or shift, rather than relying on ambiguous references to day alone. That drafting change may sound minor, but it's designed to align overtime compensation assessments with how shifts actually operate where sleepovers are involved. Second, and most importantly for many organisations, the Commission has introduced a specific rule for part-time and casual employees where a 12-hour sleepover linked shift is agreed. In those circumstances, overtime will only apply once the 12-hour threshold is exceeded. This is a deliberate attempt by the Commission to prevent automatic overtime outcomes simply because work spans a sleepover. Without this adjustment, organisations could face structurally unavoidable overtime liability, even where employees are working within reasonable and agreed hours. However, this flexibility comes with conditions. It only applies where there is a genuine agreement to the 12-hour shift and where the caps on hours before and after the sleepover are respected. For leaders, the risk here is not theoretical. If payroll systems are not aligned to recognise when a 12-hour shift has been validly agreed, or if agreements are informal or inconsistently applied, organisations may inadvertently misapply overtime rates. Accurate agreements must be documented to prevent misunderstandings and to ensure compliance with the new regulations. This is why overtime under SCHADS should be treated as a governance issue, not merely a payroll function. Clear rules, documented agreements, and tested payroll logic are essential to maintaining and managing this risk. So I'll hand it over to Paul to continue from the transition window.
Okay, look, thank you, Etta. Participants in this webinar will appreciate there's a lot of information in that, and I certainly would expect that it'll take a little while for people to get their head around the impact of the changes and how that needs to be applied within their own organisations. Suffice to say, the way in which we're characterising the period in which we're at the moment is a transition period. A period where the law has not yet formally changed, but the direction of travel towards that change is clear. The federal court decision has interpreted the existing award one way, but as Etta said earlier, the federal court was not entirely satisfied that the current award provisions were not ambiguous, and in fact encouraged the Fair Work Commission to, in a timely manner, to vary the award accordingly, which where we're at the moment. The Commission has acknowledged the ambiguity and proposed a revised framework which would soon replace it. Look, this creates a space where I suppose management or leadership judgment matters more than rigid rule following. What we're suggesting is that overreacting by immediately restructuring all rostering practices may create disruption, not only to the clients that you're dealing with, but also employees in fatigue risk and general workforce dissatisfaction. Of course, doing nothing, however, may leave known issues unaddressed once a variation takes effect. So the change does have to occur. From a governance perspective, the most defensible position is one that is deliberate and documented. That means acknowledging the forthcoming changes, that is assessing current practices and planning for implementation without unnecessary upheaval. The regulators and courts look favourably as certainly our experience on organisations can demonstrate that they are actively engaging with those regulatory developments, even where the final rules are not yet in force. Certainly silence or inaction is rarely a defensive position to take. So that leads us to what employers should do now. Well, we recommend that executive and senior managers, including HR leaders, focus on 3 immediate priorities. The first is visibility. Employers should have a clear picture of where sleepovers are used across the organisation, which roles are involved and how work is structured around them. And in doing so, assess all of the positions involving sleepovers to ensure compliance with the upcoming changes to the award, guidelines and rostering practices. I mean, this is essentially foundational. You can't manage the risk unless you can see what the problems are. So knowing what's going on in your own organisation and mapping that against what the proposed changes are likely to be. The second recommendation is accuracy. Review current sleepover rostering practice and identify any discrepancies that may lead to compliance issues. And organisations should confirm that sleepover allowances are being paid correctly at the moment, that any work performed during sleepovers is paid at the appropriate overtime rates, that shift penalties are applied consistently with the award as it currently operates. Third priority is readiness. Create the necessary agreement templates and ensure payroll systems align with the new requirements under the award for sleepover shifts. This involves preparing for the proposed variation by reviewing your payroll logic, drafting template agreements, 12-hour sleepover link shifts, which seem to be one of the more sensible variations to the award and opportunities for employers, certainly from what I can see from the decision. And ensuring managers understand both the flexibility and the limits of the new framework. The rostering arrangements are sometimes outside of the control of you as HR managers and senior managers. So getting a grip on what's occurring and ensuring down the line that those rosters are properly structured is in fact very important. So importantly, it's not about wholesale operational redesign. We're confident that the variations to the award can be hopefully incorporated within current rostering arrangements and operational needs of your organisations to suit the needs of your residents, your clients, and the people who we're all serving here. It's about ensuring that when the variation takes effect, your organisation is ready, it's compliance, defensible and operationally stable, so it can be implemented smoothly. From a management leadership perspective, the organisations certainly that navigate this change best will be those that will treat sleepover compliance as a cross-functional issue involving HR, payroll, operations and governance, rather than a narrow legal problem to be solved in isolation by one or the other. So that's very important. We've reached a point now where, as I said, when I started talking about this transition period, there's a lot of information here. And to a certain extent, we're assuming that you've had the opportunity to have a look at the draft variation to the award. But if you haven't, we would certainly encourage you to do so. It's on the Fair Work Commission website, and if necessary, we can direct you in the right, we can point you in the right direction. With the time that we've got today, and I appreciate it's very short, and again, a lot of information, we'd like to be able to answer any questions now through this Q&A session with allowing ourselves up to 15 minutes to do so. So maybe if I just pause at the moment, I'm not sure whether we've got any in the box at the moment. I'll have a look and see if there's any questions being posted. If not, can I encourage you? No, there's none at the moment. So maybe we just pause a moment. If you do have a question, if you want to post it there, then that would be, we'll deal with it now. Anything coming through? Anyone like to get the ball rolling? Maybe I should kick off, and Edda.
Sure.
I've mentioned the 12-hour span as an interesting, and I thought it was a positive step in the variation. My understanding, it means is that you can do a configuration, and correct me if I'm wrong, is you can do, for example, 8 hours immediately before a sleepover and then 4 hours immediately after. Is that correct?
That's correct, yes.
That's correct. Okay. All right. Well, that and therefore no overtime would kick in after that unless you work, for example, 9 hours before the shift, or you, as a total, you end up working, say, 8 hours beforehand and then, say, 4.5 or 5 hours immediately after the sleepover. I would have thought in those circumstances, and I'd be interested in getting in feedback from those who are listening as well, either today or generally, certainly our clients who we deal with on a regular basis, as to how they're rostering, whether this decision is going to impact them significantly, or whether the variation is simply going to be able to confirm what they've been doing, or they can make the adjustments with confidence on that. So any feedback we get on that would be great. Okay, we've got a pretty quiet group today, it looks like, Edda, but maybe I'll just then throw in another question, because, and that's really the consequences of the Fair Work Commission deciding not to make a retrospective variation to the award. You mentioned that in the presentation, and the Commission was quite adamant about that it didn't have grounds, in its view, to say they were going to apply these variations retrospectively. So that does, I suppose, leave the question, what is the risk for employers? And what do they need to do, I suppose, to assess that risk? And thirdly, like all good lawyers, I presume we're asking them they should contact us. Would that be right, Edda?
If they would like to, yes, we'd be more than happy to help.
Yeah, but just the risk, I mean, there may be risk depending upon, I mean, the Fair Work Ombudsman took a particular perspective on compliance notice, which was it pursued all the way to the and defended at the federal court decision under the circumstances in which that disability service, residential disability service provider was subject to that compliance notice. It may be well worthwhile, would it not be better, that employers might just want to reflect back on that period and see what they've been doing to see whether there is any risk there, and if so, even if it's a question mark, to make some, I suppose, internal audit rather than having to sit around and wait to see if it's all okay. What do you think?
Yeah, absolutely agree. Understanding what the organisation is currently doing will help you plan for any future risk, and also plan for the new proposed changes, which will be coming into effect quite soon as well.
Okay, all right. And if we don't have any questions, I suppose we'll get on to the next bit, which is about us connecting with those who participate in. We have a number of participants who are long-standing clients of Maguire Legal, and there may also be those, and I think there are those that registered and have logged on to this that maybe the first time they've heard both of us talk on any particular topic, Etta. How can they get in touch with us, and what's the way in which one of the best ways that we've designed for not-for-profit organisations in particular, and certainly disability and community service organisations under Maguire Legal subscribe? Just explain briefly how that works.
Sure. Well, one of the easiest ways is just to send us an email on advice@maguirelegal.com.au, or just jump on our website and use the contact form there. We do have our telephone number, which rang earlier in the presentation. But we do have Maguire Legal Subscribe, which is a fixed fee yearly subscription where you can pick up the phone or send us an email anytime you like to ask us any of those niggly questions that do come about and arise within the normal employment relationship or operational relationship as well.
Great. Okay. All right. Well, look, thanks everyone for their attendance today. And I hope this gives you a little bit of information on which you can now proceed to follow the particular changes, plan ahead and implement those smoothly within your organisation. So thanks very much, and we look forward to hearing from all of you at some point. So thank you, and good day.
Thank you, everyone.